How to participate in the California rulemaking process. Now, before we discuss specifics of participating in the rulemaking process in California, I think we need to understand some of the basics of the regulatory process in this state. By way of background, California has over 200 agencies, departments, boards, and commissions and bureaus, and they all make public policy through their authority to adopt regulations. There is a list of agencies and departments that have adopted regulations, and that can be found on the website of the Office of Administrative Law, which is at www.oal.ca.gov. OAL's website, by the way, provides direct access to the California Code of Regulations, the CCR, which is organized under various subject matter titles, of which there are 28 of them. And these titles contain the over 66,000 state regulations that are currently in effect. California's Administrative Procedure Act, the APA, contains required procedures for rulemaking and administrative hearings conducted by all these agencies and departments and boards and commissions. The state's APA, patterned after the federal equivalent, is found in chapters 3.5, 4, and 5 of the Government Code, starting with section 11340. There are also regulations, ironically, governing the APA. Those are in the CCR, the California Code of Regulations, in Title I, Sections 1 to 120. By the way, OAL's website includes checklists used by OAL to review regulations, as well as their publications, such as the California Rulemaking Law under the Administrative Procedure Act. That's a book of theirs, which is excellent to read. Generally speaking, the authority of state agencies, and I use that term agency to include all the different types, they adopt policies through rulemaking, and that is defined and restricted by the authorizing statute. And statutes usually prescribe each agency's authority to adopt policy. It's an established principle by the way of administrative law that an agency cannot exceed its legally prescribed authority to regulate. On the other hand, many statutes confer broad regulatory authority to some of these agencies, and there are opportunities you should note for interested parties, paid or unpaid, members of the public, lobbyists, attorneys, and other experts, to be informed, to observe, and to participate in rulemaking activities of these state entities. And in particular, I believe interested parties have significant access due to the language in the APA. For example, every state agency is required to annually adopt a rulemaking calendar that's published on their website. Also, agencies maintain an interested parties mailing list, and they supply notices by email or mail of rulemaking activities. And these avenues enable interested parties in the regulated community, of course, to be aware of proposed rulemaking activities of these executive branch departments, agencies, boards, commissions, and bureaus. California law also requires every state agency to satisfy the basic minimal procedural requirements that are established in the Government Code by the Administrative Procedure Act. And the APA applies to the adoption, amendment, or repeal of a regulation unless that executive branch agency or its rulemaking is expressly exempted by statute. According to OAL, California courts have long recognized that under the California Constitution, the legislature by statute may delegate quasi-legislative powers to state agencies in the executive branch as long as adequate standards are provided to guide that agency. As a result of this, the agency develops four required documents during the preliminary activity stage that initiate the formal rulemaking process: the express terms of the proposed regulation, that is the proposed text; the initial statement of reasons, called the ISOR for short, the initial statement of reasons, ISOR or ISOR; the fiscal statement, and the notice of proposed rulemaking. And these documents are initially filed with OAL and published by the agency on their website and sent directly to those who have requested the notice. and it's also set forth in the California Regulatory Notice Register. Thereafter begins the 45-day comment period, which is the opportunity for the public and, of course, the regulated community to submit written facts or email comments on all or a part of proposed rulemakings when the notice of proposed rulemaking has been published in the CRNR. According to LAL, a regulation has to be easily understandable, have a rationale, and be the least burdensome effective alternative. And of course, a regulation cannot alter, amend, enlarge, or restrict a statute or be inconsistent with or in conflict with a statute. Under the APA, again found in the government code, an agency has an option as to whether it wishes to hold a public hearing on a proposed rulemaking. However, if an agency does not schedule a public hearing and any interested person submits a written request within 15 days of the close of the written comment period, then the agency is actually required by statute to hold a public hearing. And because of this requirement, an agency usually schedules a public hearing in its initial documents, usually to coincide with the close of that 45-day comment period. The APA also requires a rulemaking entity to consider all relevant information presented to it during the comment period before adopting, amending, or repealing a regulation. After that initial public comment period, the agency will often decide to change its initial proposal, either in response to or um, for other reasons, the public comment, or of its own volition. A rulemaking agency must summarize and respond on the record to any timely filed comments. And the summary and the response of the agency to those comments have to demonstrate that they considered all the relevant material presented to them before they adopt, amend, or repeal that regulation. And an agency may respond to a comment in two different ways. According to the OAL, the agency has to either explain how it amended the proposal to accommodate or accept the comment, or two, it must explain the reasons for making no change to the proposal. And OAL says that an agency's summary and response to comments must be included in the final statement of reasons, otherwise known as the FSOR. Thereafter, the agency transmits its rulemaking file to the Office of Administrative Law for review within a year from the date that the notice of proposed rulemaking was published. So the agency has 365 days after it's noticed the proposed rulemaking to submit that final product to OAL. And then OAL has 30 working days, not calendar days, but working days, in which to review the rulemaking record to determine whether it demonstrates that the rulemaking entity satisfied all of the procedural requirements found in California's APA. Specifically, OAL reviews the rulemaking file for the agency's compliance with 6 statutory standards of review. And those are authority, reference, consistency, clarity, non-duplication, and necessity. OAL, it's important to note, is not allowed to substitute its judgment for that of the rulemaking agency regarding the substantive comment of the regulations. It merely ensures that the rulemaking body in the executive branch complied with all the procedural requirements of the APA. Now, understanding this process, we turn to participation in the rulemaking process or the regulatory process here in California. Just be aware from the outset that it's a world of its own with separate rules and procedures. And just like the legislative process, an effective advocate, a lobbyist, an attorney, or a volunteer needs to know the rules and players as well as the policy that they're advocating for or against. So how does the public participate? Well, under the APA, there are a number of opportunities for interested parties to be informed, to observe, and then to participate in rulemaking activities of state agencies and departments, boards, and commissions and bureaus. Interested parties, I think, have significant access to rulemaking, including public notice and, of course, the opportunity to comment orally or in writing. So what's the role of professional advocates in rulemaking? Well, some lobbyists do operate exclusively in the regulatory arena. But in many instances, regulatory activities are left to lawyers practicing in those particular areas. So lobbyists sometimes assist clients to meaningfully engage in those comment periods, and of course, the formal administrative hearing, as well as to navigate the agency process that's used to adopt or amend regulations. How can you make an effective agency presentation? I think effective comments are based on an understanding of the underlying statute or statutes, the factual basis that the agency is relying upon in the written record when it's proposing the regulatory changes, and an understanding of what the proposed regulatory language is not only intended to do, but will likely do. And then, of course, understanding the standards by which the regulation must comply before its adoption. So, from my perspective, your written and verbal comments should keep those points in mind. What points should you consider making at a public hearing? Well, focus on the policy, the fiscal impact as well of the proposed rulemaking and how it does or does not comply with the authorizing statute. Also, be aware that something could go awry. So expect the unexpected regarding the attentiveness of the decision makers, the questions or interruptions that might confront you when you publicly testify. Of course, try and stay on point and within the specified time limits with your presentation. Always be honest and present your strongest points for or against the proposed rulemaking. You may not have time to go through all of your points in support or opposition, so focus on those that have the strongest appeal. Mention compliance with or lack of compliance with those six standardized or standards of review that OAL has to review pursuant to the APA. And remember that those oral presentations are one component of regulatory agency advocacy. There, of course, is also the written one. There are several potential avenues for you to try and engage and impact the rulemaking process. Beware of the players in the executive and legislative branches that might be able to weigh in with a rulemaking agency or department. For example, how does the governor influence executive branch agencies? Well, obviously, if that entity is with the line authority of the governor, for example, the governor appoints the director, then he or she can issue directives. If the governor appoints all or some of the governing board members of a so-called independent agency, the governor may be able to influence one or more of those appointees. How about the legislature? How does the legislature influence state agencies? Well, when conferring their power or authority to regulate on that executive branch agency, the legislature can choose to grant a broad scope, a limited scope. They can make it a may discretionary or a shall mandatory grant of authority. Another key function, of course, for the legislature is oversight of those executive branch agencies and departments and their rulemaking activities. And through the annual budget process, the legislature clearly can exert influence by providing or removing funding or by adopting budget control language that may in fact direct agency activities. The legislature can also hold oversight or investigatory hearings to review an agency's action when they adopt regulations or try to implement laws adopted or enacted by the legislature. The legislature can also direct one or more of its control agencies, such as the state auditor or the legislative analyst office, to look into the agency's actions or inactions to either regulate or implement a statute in particular. The legislature even has statutory authority to ask OAL or relevant policy committees to review regulations. So turning to interest groups, how do interest groups influence state agencies? The main route is by taking advantage of the extensive opportunities to participate in rulemaking activities. Some interest groups go well beyond simply participating in the regulatory process. Those groups can and often do resort to the legislative arena in order to influence rulemaking. And these interest groups may work with the governor as a means of pressuring state agencies to act or not act. Unhappy with a given regulatory action, they can even initiate litigation to challenge the agency's rulemaking activities. And interest groups can also instigate media attention, press coverage regarding an agency's actions or inactions. There's also other means of challenging rulemaking activities. There are two major ways. First is any interested person can petition an agency to request the adoption, amendment, or repeal of a regulation. And thereafter, that agency or executive branch entity has 30 days to respond to the request. Sometimes this actually prompts a rulemaking project to begin in earnest. The second way is any interested party can obtain a judicial declaration regarding the validity of any regulation or an order of repeal. They do so by bringing an action for declaratory relief in a superior court, and the right to judicial determination is not affected by an interested party's failure to either petition the agency or to seek reconsideration of a petition. And so a court ultimately could invalidate a challenged regulation, for example, that was challenged in a court of law.